2020, the state against Mr. Matotsi, accused number 1, Mr. Ramavunga, accused number 2. Your Worship will note that Mr. Accused number 3, that's in the charge sheet as well as the indictment, is not present today. He will be joined next week. That's Mr. Truta. Accused number 4 present today is Mr. Mukudubane. Accused number 5 is Mr. Malaba. Accused number 6 is Mr. Ramakosi. Accused number 7, Mr. Nesani. And accused number 8, Mr. Magula. The appearances are as follow. Presiding Officer, Mr. Nemavidi. Prosecutor Advocate J.H. van der Merwe. Mr. Hansen for accused number 1. Mr. Creer for accused number 2. Mr. Kulu for accused number 4. Mr. Venter for accused number 5. Mr. Nechihawa for accused number 6. Mr. Nswane for accused number 7, and Mr. Krause for accused number 8. Your Worship, I've inquired from all parties present. It's not necessary for the use of an interpreter, so we'll proceed in English. As I indicated, the accused were arrested yesterday. I'm in possession of the J50s of all the accused. If so required by the court, I'm in a position to hand it up. Thank you. Your Worship, at this stage, all the accused are in custody. The state is not going to oppose bail. The investigating officer, Lieutenant Colonel Schneller, prepared a statement for purposes of the application. It is going to be a Schedule 5 bail application. The charges are listed in the indictment attached to the charge sheet. The indictment has been provided to all of the legal representatives of the accused. They are aware of the charges leveled against their clients. So, in line of that, if the court can maybe give guidance as to how we shall proceed with the application for bail.
Right, as a housekeeping, we are all aware of the fact that whatever is in the streets should be wearing a mask. Secondly, the questions are to the effect that social distancing should be observed. And that means that everyone has to ensure that whoever is next to them, there is a space of about 1.5 meters. The court is enjoined to enforce this type of law. And I see that on the eastern and southern side of the country, there are so many people who are not observing social distancing. And I'm not going to proceed in this court if this social distancing is not. I urge you, if you realize that you are too close to your neighbor, to whoever is close to you, can you just move out of the court in order that we proceed? And without this court, we should follow the officials who will enforce this. I'm going to adjourn for the moment to ensure that this is social distancing.
All right. Okay, nou moet die ordonnansie.
Ja, nou moet die ordonnansie. Die kas is Pretoria Sentrol. Silence.
Rise
Please,
in
please,
court.
please.
One of you must somehow do this. Move this.
Thank you, Worship.
What should happen with respect to view of the fact that this is a matter of resort to Schedule 5? Each of the attorneys or counsel shall give me an affidavit in support of the case.
Yeah.
Whereafter, at the close of the case of the case,
Thank you, Worship. Yeah. All parties have prepared statements.
May it please you, Worship, I do firstly wish to confirm our appearance of the first accused, Mr. Matotsi. Worship, the accused prepared an affidavit in support of his application for bail. I beg leave to hand up the original, which was undersigned by Mr. Matotsi and commissioned properly. Bishop, I now wish to proceed to read into the affidavit in support of this bail application by Mr. Matotsi. May I proceed, as a court please. In the Regional Court for the Regional Division of Gauteng, held at Palm Ridge, case number SCC 48 of 2020, in the matter between the State versus Tsefiwa Matotsi, statement in terms of the provisions of Section 6011B of the Criminal Procedure Act 51 of 1977. I, the undersigned, Tsefiwa Matotsi, do hereby make oath and state, I'm an adult male and a South African citizen with identity number 0877 0718 5406082. I'm the applicant in this application in which I seek relief from this Honourable Court to be released on bail. I respectfully submit, as I will demonstrate herein, that the interests of justice permit my release on bail. In any event, the dictates of fairness and justice in view of the peculiar facts herein warrant that I should not be deprived of my liberty and that I should be released on bail. Paragraph 3. I depose to this affidavit out of my own free will and have not in any way been unduly influenced to depose hereto. The facts herein contained, save where expressly indicated to the contrary, are within my personal knowledge and belief and are both true and correct. Out application in terms of Section 6011B of Act 51 of 1977, in brackets the Act, Paragraph 5. The purpose of this affidavit is to provide the Honourable Court with my personal circumstances and to address the allegations levelled against me, in brackets, insofar as they are known to me, as well as to address the factors to be considered by the above Honourable Court as contained in sections 60, subsection 4 to section 60, section 9 of the Act. Paragraph 6. I have been advised and understand that I bear the burden to show that the interests of justice permit my release and I am obliged to initiate this application. However, I will put factors before the Honourable Court to show that it is in the interests of justice to permit my release on bail. Paragraph 7. I state that the State will not be able to present any objective facts that it would not be in the interest of justice to grant me release on bail, despite the fact that I was rightfully detained. For this reason, I will hereunder deal with the events which occurred. The objective facts will not refute my version as it is the truth. Personal circumstances, paragraph 8. I'm currently unemployed as my estate has been finally sequestrated. I was, however, a registered chartered accountant but not able to work at this stage. I currently reside at 30 Green Street, Bryanston, Johannesburg, which address has been confirmed by law enforcement. I must submit that I will be moving to the following residential address on 26 June 2020, namely 6 Pitcairn Road, Blair Gowrie, Randburg, area code 2194, Johannesburg. The same address can be confirmed if same is required. Paragraph 9. I was born on 18 July 1977 and I have resided in the Republic of South Africa all my life, and I regard South Africa as my permanent place of residence. I have no intention to relocate to any other country as I love my country. I do not own any immovable assets in South Africa due to the fact that I have been declared insolvent. Paragraph 11. I do not own valuable movable assets as I permanently reside with my wife, Tabelo Grace Matutsi, who is providing for me at this stage. Paragraph 12. My friends and family reside in the Republic of South Africa. Paragraph 13. My professional occupation currently provides me with no income, as I am not in a position to practice at this time. Paragraph 14. I've been residing in the Greater Johannesburg area for the majority of my life and have been unemployed for a period of more than 2 years. Paragraph 15. I've never been convicted of a criminal offence. There are further no outstanding cases pending against me, and I can furthermore confirm that there are no other cases against me investigated by the SABC other than this matter. Merits, paragraph 16. My legal representatives have explained the provisions of section 60 in brackets 11 in brackets B of the Act to me. I respectfully make the following submissions in this regard. 16.1. I have been informed that I am accused inter alia of racketeering, money laundering, fraud. 16.2. I'm advised that I do not have to deal with the merits of the case for purposes of the bail application. However, I believe that it is appropriate to explain why I am at this stage not prepared to deal with the merits. 16.2.1. I was arrested early yesterday morning and therefore have subsequently not had a proper opportunity to consult with my legal representatives. 16.2.3. I at this stage intend to enter a plea of not guilty on the charges listed above. 16.2.4. I intend to have my day in court in order to prove my innocence. 16.2.5. I have furthermore been advised, which advice I accept being correct, that dealing with any merits at this stage in light of the aforesaid can cause me unnecessary prejudice. Flight risk, paragraph 17. I will stand my trial should it proceed against me, and there is no possibility that I will even think of not standing my trial should there be one. I trust the South African legal system and that the facts will show why I acted in the way I did. Paragraph 18. In order to persuade the above honourable court that I should be released on bail, I provide the following additional facts and information in terms of section 60 of the Act. Heading at section 60, subsection 4A, read with section 60, subsection 5 of the Act. Paragraph 19. I do not know the identity of any witness upon whom the State will rely in order to attempt to prove a case against me. In any event, I have no intention to interfere with any witnesses as I have no cause to do so, and I undertake not to do so. I maintain good relationships with people, and I bear no grudges against anyone. Paragraph 21. As previously stated, I have no previous convictions or pending cases against me. I also confirm that there is no cases being investigated by the SABC against me other than this case. Paragraph 22. All documents pertaining to this matter which I had in my possession, I have already provided to my attorney, namely Hector Hansen from Hansen Incorporated Attorneys. I thus do not have any documents in my possession pertaining to this matter. Heading at section 60, subsection 4, subsection B. Read with section 60 in bracket 6 of the Act. I respectfully submit that the facts set out above support my contention that I do not constitute a flight risk. Paragraph 24. I do have a valid South African passport. I undertake to surrender same as a condition if I am permitted to be released on bail. Paragraph 25. I will be able to raise an appropriate amount to post as bail as contemplated in subsection 13A of the Act. Heading at section 60, subsection 4C, read with section 60, subsection 7 of the Act. Paragraph 26. I have no knowledge of any evidentiary material which may exist with regard to the allegations levelled against me. In any event, I believe that whatever such evidence may be, it is in the possession of the police, alternatively the National Prosecuting Authority. It is safely secured, and I do not have access there. I undertake not to interfere with any further investigations. Paragraph 27. I'm not sure which witnesses the state will rely upon in order to attempt to prove its case against me. Nonetheless, I undertake not to communicate with any witness, whoever he or she may be, and any other persons whose names may appear on a list of state witnesses to be provided by the state. Paragraph 28. During insolvency proceedings that include the sequestration of my estate and the liquidation of their investments, I at all times offered my full cooperation and subsequently made myself available to appointed curators, liquidators, and others. This hopefully will constitute and or illustrate to the above honourable court that I am of the intention of giving my full cooperation, as I at all times had been advised to do so by my legal representatives. Paragraph 29. My continued incarceration can only prejudice me and my family and creates no benefit to the state. The prejudice referred to inter alia is duly examined in paragraphs 33 to 36 below. Reading at section 60, subsection 4D, read with section 60, subsection 8 of the Act. Paragraph 30. I have not at this stage, nor during my arrest, or at the time supplied any false information. Paragraph 31. It has been submitted that I have never been convicted on a previous conviction. Heading at section 60, subsection 4E, read with section 60, subsection 8, capital A. Paragraph 32. I respectfully submit that should I be released on bail, my release shall not disturb the public order or undermine the proper functioning of the criminal justice system. Heading at section 64, read with section 60, subsection 9 of the Act. Paragraph 33. It must be noted that I have been in custody for a period of 1 day since my arrest. Paragraph 34. I furthermore submit that I have recently been diagnosed with diabetes. Proof of same can be provided to the above honourable court in the event that same is required. I've been advised by my medical practitioners, and furthermore I've learned from medical articles published online that persons suffering from diabetes have a higher risk and or chance of dying from the COVID-19 virus. It is common cause that the said virus at this moment is a massive pandemic in our country, and I therefore submit that further incarceration will constitute a higher risk of contamination of the virus. Paragraph 35. I have furthermore been advised by my legal representatives that the trial proceedings that face me are not ordinary. The trial will be in enormous public interest. I have learned that the state has compiled massive volumes of evidence, and I will therefore need hundreds of hours of preparation with my legal representatives in order to properly prepare for trial. In the event that I am further incarcerated, I will subsequently be restricted access to my legal representatives to properly consult, peruse, and or prepare towards this very serious trial that stands before me. Paragraph 36. It must lastly be submitted that I am the father of 2 minor children, in brackets 6 and 9 years old respectively. I play a massive emotional and supportive role in their respective lives. Should I be further incarcerated until the conclusion of the trial proceedings, in brackets, which I have been advised will not be in the near future, conclude bracket, I will not be able to support my minor children whatsoever. Heading, conclusion, paragraph 37. I will comply with such conditions as the above honourable court may wish to impose. Paragraph 38. I accordingly submit that the interests of justice, considerations of prejudice, and the balancing of respective interests favour my release on bail. Bishop.
Do you confirm the contents of the affidavit in support of this application and read and executed on your action? Speak up.
Yes.
Affidavit, mark.
Thank you.
This case with that.
That's okay for that. My pleasure.
Confirm appearance on behalf of accused number 2 in this matter, Your Worship. Accused number 2 has also prepared bail affidavit in this regard, and we beg and same up to Your Worship. So may I then proceed in reading the bail affidavit. In the Regional Court for the Regional Division of Gauteng, held at the Specialised Commercial Crime Court, Johannesburg, case number 48/2020, in the matter between Andile Malusi Atwell Namabula, the applicant, and the state. Affidavit in support of bail application. I, the undersigned, Andile Malusi Atwell Namabula, hereby declare under oath as follows. Paragraph 1. I'm the applicant in the above mentioned matter, an adult male aged 40, with the following personal particulars and background. 1.1. My identification number is 7910054362-084. I attach a copy hereto as Annexure AR1. 1.2. Date of birth. Was born on the 5th of October 1979. 1.3. Citizenship. I am a South African citizen by birth. 1.3.1. Travel documents. I'm the holder of 2 valid South African passports with passport numbers A023, A2, 873 and M00209-489, which passports will expire on the 12th of September 2022 and 14th February 2027 respectively. I attach here to copies of both passports as Annexure AR2 and Annexure AR3 respectively. I applied for a second passport whilst the other one was still valid, seeing that there were no further space in the initial passport for further entry and exit stamps. 1.3.2. Previous travel or residence in foreign countries. I've never resided in a foreign country, but I have travelled to various destinations in the last 5 years for business and leisure purposes. These countries include Swaziland, Sudan, Namibia, the United Kingdom, the United States of America, Zimbabwe, the United Arab Emirates, Mauritius, Germany, and the Netherlands. 1.3.3. Relatives resident outside the Republic of South Africa. I do not have any direct relatives resident outside the Republic of South Africa. 1.3.4. Outside the Republic of South Africa. None. 1.4. Personal background. 1.4.1. Place of birth. I was born in Union Hospital, situated in Alberton. 1.4.2. Schooling. I attended St. Francis College, situated in Benoni, where I successfully completed grade 12 in 1996. 1.4.3. Tertiary or other training. I attended the University of Johannesburg from 1997 until 2001, where I successfully completed my BCom degree in accounting. I further attended the University of KwaZulu-Natal in 2002, where I successfully completed a postgraduate degree in accounting. 1.4.4. Work history. I was employed as the Chief Executive Officer at VBS Mutual Bank as from 2003 until March 2017, when the bank was placed under curatorship. My duties included, but was not limited to, the drafting and implementing the turnaround strategy of the bank, raising funding, stabilizing shareholder relationship, and managing relationships with regulators. From 2012 until 2013, I was employed at a small enterprise finance agency, SEPA, Where I was employed as the Chief Financial Officer, my duties included, but was not limited to drafting and implementing the finance, property and procurement strategy, responsible for a staff completion of 18 people, responsible for the day-to-day operations of the finance, property and procurement divisions, managing relations with the Ministry of Economic Development, managing relations with the IDC, the parent company, managing relations with external auditors and the Auditor General, representing SEPA on boards of investor companies and acting in the Chief Executive Officer's capacity when required. From 2010 until 2012, I was employed at Thala Limited as the Chief Operations Officer. My duties included, but was not limited to, the drafting and implementation of the bank's strategic direction, responsible for staff completion of 305 people, responsible for the day-to-day operations of the bank's distributors network across KwaZulu-Natal, managing relationships with clients and suppliers, managing government relationships, responsible for revenue budget of 200 million, responsible for an excess budget of 160 million, and representing Thala stakeholder functions. From 2009 until 2010, I was employed at Bank of South Africa and as the Deputy Senior Finance Manager. My duties included, but was not limited to, the managing of the staff completion of 46 people, managing all business operations, daily, weekly, monthly, quarterly and annual functions of the Finance and Admin Department, managing external and internal reporting, formulating and managing financial processes, procedures and policies, managing an effective and cost-effective procurement process, compiling and managing operational and capital budgets, identifying and incorporating changes to generally accepted financial practices in the system, attending and participating in strategic decision-making of the bank, preparing input into the strategic documents of the bank to be presented to the Minister of Finance and ensuring compliance with the PFMA. I was further also employed at Absa Bank and First National Bank. I completed my articles prior to thereto at Deloitte. 1.4.5 General remarks regarding background and permanency. I have no plans, immediate or in the future, to relocate anywhere else outside the Republic of South Africa. I have strong emotional ties to the Republic of South Africa and regard same as my permanent place of abode. 1.5 Current status. 1.5.1 Address. I reside at 401 Tilford Road, Cedar Creek Estate, Broad Acres, Fourways, Gauteng. I reside at the aforementioned property with my wife and my 2 children. I was arrested at the aforementioned address. 1.5.2 Marital status and general particulars of spouse. I am married to Zaleni Msibi, who is a citizen of Swaziland. I've been married to her for 5 years and have been resident with her in Gauteng ever since we got married. 1.5.3 Dependents. My wife and I have 2 children who are respectively 4 and 2 years of age. Our children are wholly dependent upon my wife and I. 1.5.4 Occupation. I'm a self-employed as an entrepreneur. During my term at VBS Bank, I had other business interests and companies of which I was the director of. I'm still a director of various companies. 1.5.5 Income from occupation. I earn approximately 30,000 rand per month after deductions. My wife and I are further reliant upon friends and family when further funds are required to ensure that all needs are met. 1.5.6 Immovable assets. My wife and I are jointly own the property situated at 35 Libra Avenue, Sundowner, Randburg, Gauteng. We own the aforementioned property, seeing that we are married in community of property. The aforementioned property, which is the only property registered in my name, currently vests in the trustees of my insolvent estate, which is subject to a petition which has been filed at the Supreme Court of Appeal with case number 242/2020. 1.5.8 Availability and sources of funds for bail. I can afford to pay bail in a reasonable amount. I have to pause at this junction and bring it to the court's attention that both my accounts, which I had with Investec and ABSA, have been frozen subsequent to the final sequestration order on the 23rd of August 2019. Paragraph 2, History of Antisocial Behavior. 2.1, Previous convictions. I have no previous convictions. 2.2, Pending criminal cases. I have no pending criminal cases. Paragraph 3, Arrest and factual background thereto. 3.1, Date of arrest. I was arrested on the 17th of June 2020 when various members of the South African Police Services arrived at my primary residence with a search and seizure warrant. I was arrested subsequent to the search and seizure warrant, which was performed by several members of the South African Police Services. 3.2, Offences charged with. I've been informed that I'm charged with various offences being fraud, theft, corruption, money laundering, and racketeering. 3.3, Intended plea. I intend to enter a plea of not guilty against all charges preferred against me. 3.4, Defence. It is common cause that an inquiry in terms of Section 136 of the Financial Sector Regulators Act 9 of 2017 was held at Workman's Attorneys in 2018, in which inquiry I testified. I gave my full cooperation since the inception of such inquiry, and I've ever since complied with due legal process whenever it was required of me. The well-known Terry McCow report was released soon after the completion of the aforementioned inquiry with title The Greatest Bank Heist. Mr. McCow EC is the author of the report, and he was assisted by Workman's attorneys who also happened to be the attorneys who was instructed to launch an urgent sequestration application against my wife and I in 2018. From the information in the public domain, such as the McCow report and the sequestration proceedings, it is alleged that from at least 2017 until the appointment of the curator, Mr. A. Ruplal, on the 10th of March 2018, VBS fell prey to a fraudulent scheme of epic proportion, which has resulted in a loss of the bank of approximately 1.5 billion rand. It is further alleged that I was part and parcel in the execution of the alleged fraudulent scheme with other individuals. It was then further specifically alleged that I accepted a payment of 15 million rand, being a bonus from Bele. I herewith yet again confirm that the 15 million rand bonus, which was referred to in the affidavit deposed by Anders Ruppel in the sequestration proceedings, were in fact not a bonus, but rather money received for services rendered by Dambale Holdings Pty Limited. The primary evidence upon which reliance is placed to assert that I was part and parcel of the fraudulent scheme is the affidavit furnished by one of the alleged co-perpetrators.
I've just gone through the affidavit which your attorneys and you guys have. You seem to be raising a defense in this affidavit. So I have to advise you first. The record of this bail application shall form part of the record of the trial following upon such bail proceedings. If you elect to proceed using the route your attorneys follow, this defense which you raise may confront you to your trial. Do you want this to go on record? You will consult this.
Thank you very much.
To confirm.
And then procedure. I will then just start off with the paragraph which I ended off with. I can't remember which word I finalised that paragraph. The primary evidence upon which reliance is placed to assert that I was part and parcel of the fraudulent scheme is the affidavit furnished by one of the alleged co-perpetrators, Kopi Mukudubwana, to the investigators appointed by the South African Reserve Bank under Section 134 of the Financial Sector Regulations Act 9 of 2017. The gist of my explanation for the receipt of the 15 million rand from Vele can be explained in that I'm a director of Dambale, which with the Zulu Trust is a 100% shareholder in Dambale. Vele appointed Dambale to structure and negotiate the purchase of the interest of one of Mr. Mslanga's in Gulela Service Group. For effecting the successful purchase of Gulela by Vele, Dambale would receive an introductory fee of 2% and a success fee of 3% calculated on the 300 million which Vele would pay in acquiring those interests in Gulela Holdings. As a result of the successful purchase of those interests by Vele, Vele paid 15 million to Dambale. The 15 million payment was received by Dambale as remuneration for effecting the purchase of Gulela by Vele. I did not receive any money, Dambale did. There is no evidence to sustain a conclusion that I acted in concert with other alleged perpetrators so as to appropriate any monies. The aforementioned explanation was already in the public domain by 16 July 2018 when I deposed to a sworn affidavit which forms part of the sequestration proceedings brought against me. In my answering affidavit, I explained in great detail that at no stage whatsoever was I a participant in the fraudulent scheme which I was allegedly a part of. I further stated that I do not bear any personal knowledge of the details of such alleged fraudulent scheme. I remain steady in my defence relating to the aforementioned allegations and yet again deny that I was part deny that I was part and parcel of the execution of an alleged fraudulent scheme with other individuals as alleged in the founding affidavit both by Amish Rupla in the sequestration proceedings. I further vehemently deny that I ever perpetrated any fraudulent act against VBS Mutual Bank or anyone else and further put the state to prove the contrary. I have further cooperated with the trustees of my insolvent estate and have since the 23rd of August 2019, when the estate of my wife and I was placed under final sequestration, attending to all inquiries held in terms of Section 152 of the Insolvency Act. I can further confirm that I voluntarily initiated correspondence through my attorneys of record, Robert H. Buerta, Missy and Kruger, by writing to the National Prosecuting Authority as well as to the Director of Priority Crime Investigations on the 19th of November 2019. In same correspondence, it was made clear that I'm uncertain as to whether or not there's any criminal investigations pending against me. I further made it clear that should there be such investigations pending, I would be willing to cooperate with due legal process and would further be willing to report to the authorities to facilitate same, even if it was to subject myself to an arrest. It was also mentioned by my attorneys of record that they were of the opinion that such appearance should be effected by means of the J175 summons and not an arrest due to the history of this matter. The same letter was transmitted to Mrs. Cormier from the National Prosecuting Authority on the 25th of November 2019. I attached letters here to mark as annexure of AR4 and AR5 respectively. My attorneys of record received a response from the officers of the National Prosecuting Authority on the 25th of November 2019, in which correspondence they confirmed receipt of the correspondence of the 19th of November 2019. It was further made clear in the letter that my correspondence of the 19th of November 2019 would be provided to Advocate George Walloy, the Acting Director of Public Prosecutions North Gauteng, Pretoria, for him to consider. Correspondence is attached here to as Annexure AR6. My attorneys of record transmitted further correspondence to the email addresses as provided by the National Prosecuting Authority in their correspondence of the 25th of November 2019, in which correspondence my attorneys of record requested that they be provided the contact details of Advocate George Walloy to determine whether or not there are any pending criminal investigations and in addition whether my attorneys can assist with anything. The email correspondence is attached here to AR7. No response is subsequently forthcoming from the National Prosecuting Authority. Paragraph 4, submissions regarding factors to be considered when deciding whether bail should be granted. 4.1, Schedule of Criminal Procedure Act 51/1977. Matter results, and I've been advised that the offence that I'm being charged with falls under Schedule 5 of the Criminal Procedure Act. 4.2, considerations in terms of Section 60, 4A to E. 4.2.1, Section 60, subsection 4A, danger to public or individual safety. I respectfully submit that my release on bail will not endanger any person's safety. My personal profile as set up here and above clearly shows that I'm not a person with a disposition to violence. I harbour no resentment towards any particular individual or to the public in general. I've not displayed any inclination to commit violent crimes in my previous conduct. I've not displayed any disposition to commit offences referred to in Schedule 1, as is clear from my profile. In addition, I've never committed a Schedule 1 offence while I was released on bail. 4.2.2, Section 60, subsection 4B, likelihood of evasion of trial. I would respectfully submit that this likelihood does not exist. I do not wish to evade my trial and live the life of a fugitive. I cannot afford to forfeit any amount that might be set as bail. I further have my family and career, which factors tie me to the area in addition to the fact that I've lived in the area my entire life. I further undertake to adhere to any bail conditions that the court might be fit to impose. 4.2.3, Section 64, subsection C, interference with witnesses or evidence. I respectfully submit that there is no likelihood that I will interfere with any of the state witnesses. I do not have any insight as to the exact allegations against me. I do not know what state the investigations are, and I furthermore do not have access to the evidential material held by the investigating officer. I have no knowledge as to the identity of the prospective witnesses that the state intend to call, and in the event that their identity should become known to me, I would not interfere or attempt to intimidate them due to the fact that I intend to stand my trial and clear my name against all allegations which might tarnish my good name. 4.2.4, Section 60, subsection 4D, jeopardy to the functioning of the criminal justice system or bail system. I would submit that I do not pose any danger to the functioning of the criminal justice system or bail system. I have not furnished any false information at the time of my arrest or for purposes of these proceedings. Paragraph 4.2.5, Section 60, subsection 4E, exceptional circumstances present or absent, which may lead to the undermining of public order or peace. I respectfully submit that there are no exceptional circumstances which may lead to the undermining public order or peace should the court decide to grant me bail in this matter. 4.2.6, the provisions of section 60, subsection 9, the interest of justice in relation to the right to be released on bail. I respectfully submit that I will be prejudiced in the event of being further detained and that the conditions in prison are most appalling. In this regard, I request the Honourable Court to consider that I'm not a flightless, that I have no desire to abscond or evade my trial, as it is my intention to stand my trial in clear my name. I further urge the Court to consider the period that I'm to be detained until this matter reaches finalisation, and in fact the criminal trials can take a considerable period of time until finalisation. Apart from the fact that the period of detention cannot be estimated with any form of precision at the moment, I humbly request the Honourable Court to take into account that I will not earn any income whilst so detained and therefore stand to suffer considerable financial loss. I'll also urge upon the Honourable Court that should I be detained and refuse bail, that I would be severely prejudiced in the preparation of my defence. It is extremely difficult to consult with a legal practitioner from inside prison, and I have no doubt that my continued detention will seriously jeopardise my preparation for trial. 4.2.7, other relevant factors to be considered by court. I respectfully submit that the interests of justice permit my release on bail, and that I'm therefore entitled to be admitted to bail. I submit that the following facts in totality constitute that I should be released on bail. As I've stated here and above, I do not intend to evade my trial. I have several factors that tie me to the province of Gauteng, such as my family, my relationship with my friends and community. I'm not in flight risk due to the fact that I cannot afford to ask for a fugitive. I'm not in the financial position to be able to forfeit any amount that might be set as bail. I submit further that I'm willing to abide by any condition the court may deem fit to impose. It is further my belief and submission that should this matter proceed to trial, I will be in a position to clear my name of these allegations. I respectfully submit that, taking into consideration separately and cumulatively all factors mentioned here and above, I have satisfied my burden of providing that the interests of justice clearly permit my admission to bail. Paragraph 5. In the premise and taking into account the relevant schedule of the charges resolved under, I respectfully submit that the court should grant me bail in the amount appropriate and within such conditions as the court may deem fit. And it has been deposed and commissioned this morning, Your Worship.
Do you confirm the contents of the affidavit in support of the application which was already agreed with the Worship? I confirm. Accepted and much.
That's the case for the applicant. Thank you very much.
As the court pleases, Your Worship, firstly, if I may apologize for not having introduced myself.
I appreciate it.
Thank you, Your Worship. There was a lot of running around. I'm not familiar with the surroundings. Thank you very much, Your Worship. On behalf of accused number 4, Mr. Kobodwane. Statement was prepared, signed by Mr. Kobodwane. If I may have the Worship to read this into the record. In the Magistrate's Court for the Magisterial District of, sorry, that is the original commission. Oh, I'm sorry, Worship. It's a specialized commission. Thank you, Worship, for the correction. As a heading, I'll make the amendment. In the matter between the state and Poppy Kobodwane accused, statement in terms of the provisions of section 62B of the Criminal Procedure Act 51 of 1977. I, the undersigned Poppy Kobodwane, do hereby make oath and state I'm an adult male and a South African citizen with identity number 841125 5281082. I am the applicant in this application in which I seek relief from this honorable court to reduce the amount as requested by the state in the amount of 100,000 rand in brackets the bail amount. I respectfully submit, as I will demonstrate herein, that the interest of justice to lower the amount, the bail amount, and in any event, the dictates of fairness and justice in view of the facts herein warrants that the bail amount is excessive. I make this affidavit of my own free will and have not in any way been unduly influenced to propose thereto. The facts herein contained are true and correct and are, save where the contrary is indicated, within my personal knowledge. The allegations set out below, which constitute legal submissions, are based on advice received from my legal representative, and I verily believe such advice to be true, to be correct. Sorry. At application in terms of section 62B(a) and B, Roman figure 1 and Roman figure 2 of the Criminal Procedure Act 1 of 1977, the Act. The purpose of this affidavit is to provide the above honorable court with my personal circumstances as well as address the factors to be considered by the above honorable court as contained in section 60 of the Act. I've been advised and I understand that I bear the burden to show that the interest of justice permits my release as a reasonable amount and that I am obliged to initiate this application. Personal circumstances. I'm a businessman and I reside at 29 Bedford Road, Bryanston, Johannesburg. I hold a BCom degree, specializing in investment management and corporate investment banking. I have resided in the Republic of South Africa all my life, and I have frequently traveled abroad for work and leisure. I regard South Africa as my permanent place of residence. I worked as head of treasury for VBS Mutual Bank, bracket VBS, for the period of from the period 8 August 2016 to 22 May 2018. Following an investigation into large scale of fraud and theft by executive VBS launched sequestration proceedings against me in South Gauteng High Court under case number 25058 of 2018. The matter was heard before Judge Dr. J. A provisional sequestration was ordered against me on the 1st of August 2018 and made final on the 28th of November 2020. Oh, sorry, this is 2019. My insolvent estate was registered with Masters of the High Court under reference number G779 of 2018, and Harvard Corporate Rescue Services and Honey attorneys were appointed as joint provisional liquidators to the estate. The sequestration is exacerbated by the fact that I am currently unemployed and I'm completely dependent upon family to assist with legal fees and bail. Like this, I will stand my trial should it proceed against me. I trust the South African legal system and that the facts will show that I'm not guilty of the accusations leveled against me. In order to persuade the above honorable court further, I provide the following additional facts and information in terms of section 60 of the Act. At section 62B and B, Roman figure 1 and Roman figure 2 of the Act. Section 62B(a) provides that 2B(a), if the court is satisfied that the interest of justice permits release of an accused on bail as provided in subsection 1, and if payment of sum of money is to be considered as a condition of bail, the court must hold a separate inquiry into the ability of the accused to pay the sum of money being considered or any appropriate sum. B. If after an inquiry referred to in A is found that accused is 1. Unable to pay any sum of money, the court must consider setting appropriate conditions that do not include an amount of money for the release of accused on bail, or must consider the release of the accused in terms of guarantee as provided for in subsection 15 of B and or 2. Able to pay a sum of money, the court must consider certain conditions for the release of the accused on bail and sum of money which is appropriate in the circumstances. I respectfully submit that consideration of my personal circumstances as above mentioned, that the bail amount as required by the state is not appropriate. It is my further respectful submission that should bail for me be set in the amount required by the state, that it will effectively amount to refusal of bail for me, as I'm only able to raise, with assistance of family and friends, the amount of 20,000 rand, in brackets, 20,000 rand, close brackets. The constitutional right to be released on bail would become meaningless where an excessive amount is fixed. Author Steyler in Constitutional Criminal Procedure Act 1998 at 145 notes that an excessive bail amount is an indirect and unconstitutional way ordering the further detention of an accused. See also State versus Jacobs, 2011, Volume 1, SACR 490, ECP at paragraph 10, and see furthermore State versus Betani, 2007, Volume 2, SACR 590, at para 10, where Jafta JA, as it then was said, fixing bail at an excessive amount in a case involving a poor person, such as the present appellant, is tantamount to a refusal of bail. At section 64A, read with section 60 sub 5 of the Act. I do know the identity. I do not know the identity of any witnesses upon whom the state will rely in order to attempt to prove a case against me. In any event, I have no intention to interfere with any witnesses, as I have no cause to do so, and I undertake not to do so. I have no previous convictions. I have not been released on bail pending any charges. I'm not disposed to violence. At section 64, read with section 66 of the Act, I respectfully submit that the facts set out above support my contention that I do not constitute a flight risk, whereas I'm in possession of the South African passport. I'm not in possession of any other travel documents and undertake not to apply for such documentation pending the finalization of these proceedings. I do not have the financial means to travel to any other country as detailed above. South African borders remain closed for travel between countries in consideration of COVID-19 pandemic. In addition, I'm willing to surrender my passport to the investigating officer should it be a condition of bail. At section 64, read with section 67 of the Act, have no knowledge of any evidential material which may exist with regard to the allegations level of offence being. In any event, I believe that whatever such evidence may be, it is in possession of the police, it is safely secured, and I do not have access thereto. I undertake not to interfere with any further investigations. I'm not sure which witnesses the state will rely upon in order to attempt to prove its case against me. Nonetheless, I undertake not to communicate with any witnesses, whoever he or she may be, and any other person whose name may appear on a list of state witnesses to be provided by the state. At section 64E, graduate section 68A of the Act, I respectfully submit that I be released. Should I be released on bail, my release shall not disturb the public order or undermine the proper functioning of the criminal justice system. In conclusion, I will comply with such conditions as the above honorable court may wish to impose. I accordingly submit that the interests of justice, consideration of prejudice, and the balancing of respective interests favor my release on bail. I further respectfully submit that a proper case has been named out for my bail to be fixed in the amount of 20,000 rands. 20,000 rands in bracket, as a result of my personal circumstances as detailed above. Signed, Poppy Dongelani Kowa. Thank you.
Do you confirm the contents of the affidavit to support the application as read and received by your attorney?
Yes, I do.
Affidavit accepted and not
As the court pleases, Worship. That is the case.
I confirm my appearance on behalf of the accused number 5, Mr. Malaba. This is to place on record an advocate Painter instructed by Rogers Division of the Attorney. With the legal court division, may I proceed to read into the record of the bail application?
You have to read it only now. You have to end in the original application.
Yes, Your Worship, I may end that up. Your Worship, I do apologize, unfortunately it's handwritten. Well, again, I have been briefed at very late, Your Worship, so if there's any unclarity on my handwriting, please help me to... In the Specialized Commercial Crimes Court for the region of Ekurhuleni Central, held in Palm Ridge, case number SCC C48 of 20. It's called bail application information supplied by the accused under oath. I, in the front class, Kelvin Sipol Malaba, do hereby declare under oath as follows. Paragraph 1. I was informed by the court that anything that I might testify during bail proceedings may be used in my trial against me. I understand and accept it. My full names and surname as stated above is correct, and my identity number is 7305 02 6246 088. Paragraph 2. I do have a passport bearing number M002 54567. I use my passport for the following reasons. Mainly for holidays, and during March this year I went to Botswana for a wedding, and I travel approximately plus minus twice per year outside the Republic of South Africa, and I confirm that I've handed my passport to the investigating officer this sworn through my legal representative. Paragraph 3. I'm a citizen of South Africa since 2002, and my permanent residential address since 2010 is 708 Paddock Close, Fourways, and my cell phone number is 063 140 7577. My permanent work address since 2019 is 708 Paddock Close, Fourways. Paragraph 5. My profession is I'm a chartered accountant and I am self-employed. I currently use my cell phone as the cell phone number for, I currently use my cell phone number as the number for my business. Paragraph 6. Confirm that I am married. My wife's name is Jacqueline Malava. And her telephone number is 073 649 4814. My wife is also currently self-employed. Paragraph 7. I have 3 dependent children who live at 708 Paddock Close, Fourways, of which 2 are scholars and 1 a student at UCT. My monthly gross income is 25,000 and my net 18,000. Paragraph 8. I am the registered owner of the following movable property, namely a Land Rover Discovery valued at around 300,000 rand, Audi A3, which the value is unknown, and Audi A1, the value is also unknown. Paragraph 8. Subsection 1. I confirm I have no previous convictions or any pending cases or charges against me, and therefore I am a first offender. Paragraph 9. I respectfully submit that my release is going to be in the interest of justice for the following reasons. 9.1. That I will not disturb the public order or undermine the public peace and security. 9.2. That it is not my intention whatsoever to hinder the investigations in this case and or interfere with the investigate the officer and or make the arrest of further suspects in this case impossible. Further, or commit any further offences of a similar nature like the one I have been charged with and or abscond and not stand my trial. Paragraph 9.3. I will under no circumstances whatsoever direct or indirectly interfere with the police investigation or hinder such investigation. 9.4. I will not attempt in any manner to influence or intimidate witnesses in this matter. I will further not attempt to destroy any evidence in this matter and will prevent witnesses to come and testify. 9.5. I will in no manner whatsoever undermine the objects or the proper functioning of the justice system, including the bail system, or place such in danger. Paragraph 9.6. I will assist the police in their investigation through my legal representatives as much as possible as I can. I will subject myself to the advice of my legal representatives in this regard. Paragraph 9.7. I will attend my trial and remain present until finalization of this case against me. 9.8. I will not flee or leave the Republic of South Africa due to the fact that I have a responsibility towards myself and my family, which depend on me for maintenance. 9.9. I will satisfy no matter how strict the conditions set by this honourable court concerning the bail conditions. I will subject myself to these, though I am told and trust so, that it is necessary. That means that I will have to report at a specified police office or police station daily, but it would include that I be restricted to a specified area and I would not be allowed to leave the area without permission of a person allocated by the honourable court. Paragraph 9.10. I understand not to interfere or communicate with any state witnesses in this case. Presently there are no names and or addresses known to me. The state will make such names available to me if the state is of the opinion that I will possibly know the names of the state witnesses. And 9.11, I did not interfere and or frustrate the administration of justice. Particularly, I did not in any manner resist or hinder my arrest. I understand not to interfere or attempt to frustrate the administration of justice. Presently, I have no knowledge of the identity of witnesses. If such names can be brought to my knowledge, I undertake not to in any manner make contact with the state witnesses. 9.12. I undertake to hand in my passport or travel document with expired or valid, which is in my possession or in my control immediately to the honourable court or hand such over to the investigating officer of the court after the honourable court has granted me bail. I have no previous convictions for defeating the ends of justice and I undertake not to interfere with state witnesses and or police investigation. 9.14. I am told and trust indeed that my family and friends will contribute towards the payment of the bail, which may be set by the honourable court. I will also value my own funds for payment of bail, which may be set by the honourable court. Due to my financial state, I am in a position to pay an amount of 10,000 rand for bail, but I am either told and indeed believe the bail amount falls entirely in the discretion of the honourable court. Paragraph 10. I further confirm the following. my financial position, I am self-employed and trying to build a business. 10.2, my health is good. 10.3, my family and dependents are my children, my wife and my mother aged 71. 10.4, the threat of COVID-19, especially during this time, may lead to certain prejudice suffered by me should I remain in custody. I also have a responsibility to maintain my family. Also, my continued incarceration will lead to severe prejudice to myself, and considering this matter and the complexity thereof, I will need sufficient time to prepare with my legal representative. Paragraph 11. I am prepared to comply with the above conditions should I be released on bail. It's stated at Palmridge on this day, the 18th of June 2020, signed by my legal representative and the accused and the Commissioner of Prosecution. That's all.
Do you confirm the contents of the affidavit which was allegedly to the affidavit accepted or not?
As for the
Space for that.
that is the case.
Mr. Minister,
Good morning, Your Worship. Abdul Nechava, on the instruction of Mandula attorneys, on behalf of accused applicant number 6, Mr. Abashomi Ramikos, we have prepared an affidavit. I need to take the court in my hand in the origin of the court. Please start. May I proceed to read the affidavit into records? Lord. In the Specialized Commercial Crime Court for the Regional Division of South Gauteng, held at Palmridge. In the matter between Alashoni Parapara Ramikosi being the applicant and the state as the respondent, affidavit in support of bail application. I, the undersigned, Alashoni Parapara Ramikosi, do hereby state under oath that the facts herein contained falls within my personal knowledge and at the best of my knowledge and belief both true and correct. I am an adult male person of 46 years of age and applicant in these proceedings. I am a South African citizen and a holder of a valid barcoded identification document and currently reside at number 11A Henry Road, Rivonia, 2128 Gauteng Province. I consider the said address as my permanent address at domicilium standing. I have been residing at the said address for more than 5 years. The said house belongs to me. I have been made aware by my tenure of record of the offences leveled against me and the seriousness thereof. I have been made aware by my tenure of record of the offences against me and the seriousness thereof. I wish to place on record that I will provide my plea when the matter proceeds to trial, should there be one. However, I submit that I will tender a plea of not guilty to the same. I am confident that I will ultimately be acquitted of the aforesaid charges. I intend standing the trial until its finality in order to prove my innocence. Paragraph 5. My submission on the bail application. I'm advised that the offence for which I'm arrested for is a Schedule 5 offence. Thus, I would have to demonstrate that it is in the interest of justice that I be released on bail. I'm a qualified chartered accountant since the year 1998, having been employed previously by the South African Police Services as a Chief Financial Officer. I'm divorced to my wife since 2014 and we're blessed with 3 children aged 15, 12 and 11 respectively. The kids are in and out of my house as we share a joint custody with my ex-wife. I own the following: a house as mentioned above, valued at 3.2 million, and a Jeep valued at plus minus 624,000, and a Golf 4 valued at 60,000. I'm currently self-employed as a tax consultant, making plus minus 40,000 a month. I fully cooperated with the police when they came to arrest me. In fact, I personally handed myself at the offices of the Hawks upon hearing that they were at my house looking for me. I never and would not intimidate the complainants and or witnesses in this matter. More so, I do not even know the alleged witnesses the state intends calling. I submit that my continued detention will not be in the interest of justice, in that people who survived through my contribution will now have to be prejudiced. Thereby, in particular, my 3 children who solely rely on me for financial support. I submit that my continued detention shall lead to an adverse effect on my life and my family. I pray that this court assist me in retaining my liberty and dignity and allowing me to be released on bail pending the final session of this matter. I submit that I shall stand trial until its finality so that I will be able to prepare for the trying of this matter should it be so tried. If I were to be released on bail, this court would be promoting the constitutional principle of fair trial, in that I would be given an opportunity to properly prepare for my defense. I would also be placed in the similar position with the state to fully prepare and seek resources to aid my defense. There is nothing the state can bring to indicate that I may flight risk or that I will not stand the trial. I'm further willing to submit myself to the conditions of reporting to the nearest police station on dates and times this honorable court may order upon my release on bail. The nearest police station is... May I just approach the applicant just to make one amendment? Thank you, madam. The nearest police station is SABC Center. I am further willing to subject myself under section 62 of the Criminal Procedure Act 2007 should the court order as such. If released on bail, I'll also be able to raise legal fees for legal assistance of choice in defending this matter and not be forced to take legal aid attorney. This should however not be construed as if I doubt the capabilities of legal aid attorneys, but that it will be an attorney of financial constraints and not of choice. At all relevant and material times to this matter, and more particularly during my arrest and detention, I gave my full cooperation to the police, including the investigating officer. I submit that the state will suffer no prejudice in my release on bail, and this would be in promoting the constitutional principle of being innocent until proven otherwise. Other requirements of the law. That's paragraph 11. I do not have any previous convictions, outstanding warrants against me. I've never violated any conditions set upon me. I've no pending cases in my name, except the current case to which I'm applying to be released on bail. Paragraph 12. In terms of section 64 of the Criminal Procedure Act 1977, should I be released on bail, I will not evade my trial. I submit that I will not interfere with any witness should they become known to me at a later stage. Neither will I interfere with the investigation nor relocate or dispose of my assets in any way. I further submit that I will abide by any condition of bail granted by this court. I will attend court on any day called upon me to attend at 8:30 and stay in attendance until so accused by the court. It is my vehement that my release on bail will not undermine our criminal and bail system. Neither will same cause discomfort in the society. My granting of bail will not cause rage in the community. I submit that my release on bail will not jeopardize the security of the state, and that I will not destroy or cause to be destroyed any state property and of any evidential material. I'm advised by my attorney of record that the amount of bail is always in the discretion of the court. I'm further advised that the purpose of bail is to secure the attendance of the accused to the court, but not a fine. In this circumstance, an excessive amount of bail, which I will not be able to pay, will really defeat the purpose of bail. Looking at my posted background as stated above, it is my humble prayer that the court will not find it difficult to release me on bail in the appropriate amount. I humbly pray that the Honorable Court grant me bail. Properly signed and commissioned. If there's no opposition from the state, may the affidavit be admitted into record.
Do you confirm the contents of the affidavit as I have read by counsel?
That is the case for the applicant.
May it please the court, your worship. I confirm my appearance for the applicant in this matter as applicant number 7, Ernest Nasani. Your worship, the applicant has prepared an affidavit, and I would like to apologize for the affidavit. It's handwritten from your worship. May I beg you to continue the original worship. As a court, this is your worship. In the regional court for the regional division of Gauteng held at the Specialized Commercial Crimes Court, Johannesburg, case number 48/2020, in the matter between the state and Ernest Nasani, the applicant. Affidavit in support of the application. Paragraph 1. I, the undersigned Ernest Tifedindudu Nasani, identification number 7811035453-086, do hereby make the following statement under oath and say that I am a male person with the above identification number who resides at number 15 Haku Crescent, Willow Acres Estate, Pretoria, and an applicant in this proceedings. 1.2. The facts herein proposed to fall within my personal knowledge and are to the best of my knowledge, both true and correct unless the context hereof indicates otherwise. Where I make submissions of legal nature, it will be so on the basis of the advice sought from my legal representatives and which advice I accept as correct. Paragraph 2, the background to this application. 2.1. I was arrested on Wednesday, the 17th June 2020 by members of the South African Police Services at the Pretoria Central Police Station after handing myself to them after learning that they were looking for me. 2.2. During the process of my arrest, I was informed that I am faced with the charges of 1. Racketeering, 2. Theft, 3. Fraud, and 4. Corruption. 2.3. For the purposes of this application, I must state that 2.3.1, I do not have any previous convictions. 2.3.2, there are no pending cases against me. 2.3.2, I do not have any relatives outside the Republic of South Africa, nor do I have any assets or property, be it fixed or movable, outside the Republic of South Africa. 2.3.4, I was born in the Republic of South Africa and can therefore safely submit that I am a citizen of the Republic of South Africa. 2.3.5, I am married to Onika Nasani in terms of civil union, and we are blessed with 3 children aged 12, 10, and 5 years respectively. 2.3.6, all the 3 children are still minors and are still at school. 2.3.7, at the time of my arrest, I was no longer employed but was assisting my wife in the running of her business. 2.3.8, in addition to the identification book issued by the South African Department of Home Affairs, I had a passport which was issued to me in 2008, and I am willing to hand same to the investigating officer in this matter for the purposes of this application. 2.3.9, I was never arrested, never admitted today, and therefore never skipped any bail or nor contravened any bail condition. 2.3.10, I do not know the state's potential witnesses to testify in the criminal trial against me, and therefore there are no chances that I am likely to interfere or influence with such witnesses. 2.3.11, in the same way, I do not have any intention to interfere with the investigations in this matter. Paragraph 3, the charges leveled against me. I have been advised by my legal representatives that the charges as mentioned in paragraph 2.2 above fall within the ambit of Schedule 5 of the Criminal Procedure Act, Act 51 of 1977 as amended. 3.2. I am therefore advised that in terms of the provisions of Section 6011B of the Act, I have a duty to convince the above honorable court, and which honors is on the balance of probabilities that the interests of justice warrant for my release on bail. 3.3. I therefore submit that in the light of the factors highlighted above, I do not pose to be a danger to the society nor the criminal justice itself. 3.4. As the matter stands, I submit that the state's case is weighed against me and therefore intends tendering a plea of not guilty to such charges should the matter proceed to trial. 3.5. I was also advised not to disclose the nature of my defense, as at this stage I do not have a full disclosure of the state's case against me. 3.6. I further undertake not to bring the bail system into disrepute and therefore undertake to attend the criminal trial against me until such matter is finalized. Wherefore, I submit that I am a candidate to be admitted to bail and therefore pray that I be released as paid for under the circumstances. Your Worship, the affidavit has been signed by the applicant in the matter. It has been initialed by both the applicant and also the Commissioner of Courts as a confidence.
Do you confirm the contents of the affidavit as mentioned in the council? I do. Accepted and not
As a court pleases your worship, this constitutes the applicant's case, your worship. As a court pleases.
Mr. John? I please continue to. Your worship, I really need to end up signing the condition that they were supported an application for that. Please, your worship, I beg leave to read the affidavit of the record. The Regional Court for the Regional Division of Gauteng held at the Specialized Commercial Crimes Court, Palm Beach. In the matter between Polis and Duchenne Mangula, which is the accused of an applicant on the 8th and the state, an affidavit. I, the undersigned, Polis and Duchenne Mangula, hereby make oath on the state as follows. 1. I'm the applicant in this, an application for bail and an adult male South African citizen aged 44 with the following personal particulars and background. 1.1. Identification number. My identification number is 760314546383. I attach a true copy of my identity document hereunto and marked as Annexure PN1. 1.2. Date of birth. I was born on the 14th of March 1976. 1.3. Citizenship. I'm a South African citizen. 1.3.1. Travel documents. I have been issued with a valid South African passport. A true copy of my passport is hereunto annexed as Annexure PNN2. I will adhere to any reasonable condition of bail the above honourable court may be fit to impose regarding the application and use of travel documentation for the full duration of this matter. 1.3.2. Previous travel or residence in foreign countries. I have travelled to numerous countries for business purposes. I have visited Japan, the United States of America, Nigeria, Tanzania and the United Arab Emirates. I have not travelled since 2018 though. 1.3.3. Relative resident outside the Republic of South Africa. I have no relative resident outside the Republic of South Africa. 1.3.4. Assets outside the Republic of South Africa, none. 1.4. Personal background. 1.4.1. Place of birth. I was born in Michelele in Venda in 1976. 1.4.2. Schooling. I attended the Patrick Romano High School. I matriculated in 1994. 1.4.3. Tertiary or other training. In 1995, I commenced my studies at the University of Venda in Thohoyandou in the Limpopo province. I read towards a Bachelor of Science in Zoology and Biochemistry. I graduated in 1997. In 1998, I commenced with an honours degree in medical sciences, specifically relating to cell biology at the University of Cape Town.
Subsequent to obtaining my honours degree in medical science at the University of Cape Town, I commenced with a bachelor's degree of commerce in accounting sciences. I commenced with the course in 2000 and graduated in 2005. In 2013, I successfully completed my honours degree in financial management through the University of South Africa. During the course of 2014 and 2015, I completed a master's degree in development finance at the University of Stellenbosch. 1.4.4 Work history. In 2005, I commenced my employment at the Alexander Forbes. I was employed as a pension fund bookkeeper. In 2008, I was offered a position at Deloitte, where I was employed in my capacity as a pension fund audit clerk. I was employed at Deloitte for approximately 3 years. In 2010, I became a business manager at Standard Bank. In 2012, I was promoted within Standard Bank to the position of the credit risk manager, which position I held for approximately 3 years. Since 1 August 2014, I was employed by the Public Investment Organisation, hereafter referred to as the PIC, as a credit risk analyst. I was later promoted and held the position of senior credit risk analyst. I was then again promoted to the position of acting head of risk. In 2015, I became the executive head of risk at PIC. By virtue of my position in the PIC, I was nominated to represent PIC on the boards of the following companies or institutions: the Trust for Urban Housing Fund, the Bachilo Hospital, the VBS National Bank, Makaya Housing, Daybreak Poultry Farms. I am, however, currently unemployed after I was dismissed by the PIC on the basis of performance-based issues. 1.4.5 General remarks regarding background and permanency. I've been residing in Gauteng since I commenced with my employment at Alexander Forbes in 2005. I'm currently married and I have 3 children. My family therefore ties me to the division of this honourable court. I've spent the most part of my professional career in Gauteng and I have no intention to relocate elsewhere. I furthermore do not have the financial means to flee, as I am currently unemployed and I have no inclination nor the means to live the life as a fugitive. 1.5 Current status. 1.5.1 Address. I reside at 11 Tain Avenue, Robindale, Randburg. I own this property. I attach here to a utilities bill marked as Annexure PMM3 in confirmation of this fact. I was also arrested at the premises by the police on 17 June 2020 at approximately 8. 1.5.2 Marital status and general particulars of spouse. I am married to Sandra Magula. In terms of customary law, we have been married since 2007. 1.5.3 Dependents. I have 3 children. I have 2 daughters who are currently 9 and 7 years of age. My youngest son is currently 1 year old. 1.5.4 Occupation. See paragraph 1.4.4 Supra. I am presently experiencing great difficulties on securing employment. 1.5.5 Income from occupation. I currently have no income as I am unemployed. 1.5.6 Other sources of income. I have liquidated my pension fund in order to maintain my family for the time being or until such time as I am able to secure permanent employment. 1.5.7 Assets. I own the property I currently reside in. I own a 2006 Mercedes-Benz CLK 350 to the approximate value of 60,000 Rand. I also own a Mercedes-Benz C200, which is still the subject of an installment sale agreement. 1.5.8 Availability and sources of funds for bail. I can afford to pay bail in a reasonable amount. I do not, having lost my employment some 2 years ago, unlimited access to financial resources. I have available and can raise an amount of 15,000 Rand for bail. I cannot afford this amount to be forfeited to the state due to a failure to comply with the conditions of bail. 3. History of anti-social behavior. 2.1 Previous convictions, none. 2.2 Pending criminal cases, none. 4. Arrest and factual background thereto. 3.1 The date of my arrest. I was arrested on 17 June 2020 at my place of residence. 3.2 Offences charged with. I am charged with the offences of racketeering, theft, fraud, corruption and money laundering. All these charges emanate from the so-called VBS Bank fraud. 3.3 Intended plea. I intend to plead not guilty. 3.4 Defence. I have been informed of my right to remain silent at this stage and not to disclose the basis of my defence, and safe to deny all allegations preferred against me, elect to do so and to reserve the right to respond to whatever allegations the state may make during these proceedings. Submissions regarding the factors to be considered when deciding whether bail should be granted. 4.1 The schedule of the Criminal Procedure Act 51 of 1977 the matter resorts under. I have been advised that the offence that I am being charged with falls under Schedule 5 of the Criminal Procedure Act 1977 due to Your Worship, that is an error. It's a result under Schedule 5 by virtue of the fact of the value of the amounts involved. I'll just correct that. Excuse me. Considerations in terms of section 64 sub A to E. Endanger to public individual safety. I respectfully submit that my release on bail will not endanger any person's safety. I harbor no resentment toward any particular individual or to the public in general. I intend to stand trial in order to clear my name of these allegations. Section 64B, the likelihood of evasion of trial. I would respectfully submit that this likelihood does not exist. I do not wish to evade my trial and live the life of a fugitive. I furthermore do not have the means, financially or otherwise, to sustain such a life. I am willing to provide the investigating officer with my passport. I cannot afford to forfeit any amount that might be set as bail. Furthermore, I have lived in this area my entire professional life. I further undertake to adhere to any bail condition that the court may deem fit to impose. I interpose to mention that Advocate Terry Matau's report was published in or about October 2018. I was incriminated in that report and I was therefore aware of the fact that I might be arrested for this matter. Despite the aforementioned, I have made no attempt to evade the law. 4.2.3 section 60 sub 4 sub C, interference with state witnesses or evidence. I respectfully submit that there is no likelihood that I will interfere with any of the state witnesses. I do not have any insight as to the exact allegations against me. I do not know what stage the investigations are at, and I furthermore do not have access to any evidentiary material held by the investigating officer. I have no knowledge as to the identity of prospective witnesses that the state intend to call, and in the event that their identity should become known to me, I would not interfere or attempt to intimidate them due to the fact that I intend to stand my trial and clear my name against any allegations that might tarnish my good name and reputation. Section 64D, jeopardy of functioning of criminal justice system or bail system. I would submit that I do not pose any danger to the functioning of the criminal justice system or the bail system. I have not furnished any false information at the time of my arrest or for purposes of these proceedings. Section 64E, exceptional circumstances, the presence or the absence thereof, which may lead to the undermining of public order or peace. I respectfully submit that there are no exceptional circumstances which may lead to undermining public order or peace should the court decide to grant me bail in this matter. The alleged crime against me has attracted media attention, but bail is, contrary to the public belief and opinion, not punitive in nature, and the issue of bail shall not be seen as some form of anticipatory punishment. I have been advised, which advice I accept, that this factor is not applicable to my application, but that legal argument will be proffered on this issue if the necessity arises. The provisions of Section 69, the interest of justice in relation to the right to be released on bail, I respectfully submit that I will be prejudiced in the event of being further detained, in that the conditions in prison are most appalling. In this regard, I request the Honourable Court to consider that I am not a flight risk and that I have no desire to abscond or to evade my trial, as it is my intention to stand my trial to clear my name. In the current circumstances of a worldwide pandemic, I submit that my continued detention will increase my risk of being infected with COVID-19. I further urge the Court to consider the period I am to be detained until this matter reaches finalization, and the fact that the criminal trials can take a considerable period of time before being finalized. Apart from the fact that the period of detention cannot be estimated with any form of precision at the moment, I humbly request the Honourable Court to take into account that I will not be able to earn any income while so detained, and I stand to suffer considerable financial loss as a result thereof, will not be in a position to support myself or finance my defence. I further stand to face inevitable prejudice should I be detained for a lengthy period of time, that I will lose my ability to generate income as my ability to secure employment and my ability to earn may be adversely affected permanently. I also urge upon this Honourable Court that, should I be detained and refuse bail, that I would be severely prejudiced in the preparation of my defence. It is extremely difficult to consult with my legal representative from inside prison, and I have no doubt that my continued detention will seriously jeopardise my preparation for the trial. Other relevant factors to be considered by the Court, I respectfully submit that the interests of justice permit my release on bail, and that I am therefore entitled to be admitted to bail. As I have stated herein above, I do not intend to evade my trial. I have several factors that tie me to Gauteng, my relationship with friends and community, and my social ties. I cannot conduct any business outside of Gauteng. I am not a flight risk due to the fact that I cannot afford the lifestyle of a fugitive. I am not in the financial position to be able to forfeit any amount that might be set as bail. I submit further that I am willing to abide by any condition the court may deem fit to impose. I humbly pray that this honourable court take into consideration that my arrest in this matter was imminent for some time. Speculation in the media has been rife as to when my co-accused and I would be arrested, and I knew that it was only a matter of time before a criminal prosecution would be instituted against me. I have not absconded or attempted to evade justice, despite the fact that I knew my arrest to be imminent. It is furthermore my belief, and I respectfully submit, that should this matter proceed to trial, I would be in a position to clear my name of these allegations, as I am confident that I will be acquitted of the charges. I respectfully submit that taken into consideration separately and cumulatively the factors mentioned herein above, I am satisfied above the Honourable Court that the interests of justice permit my release. In the premise and taking into consideration the relevant schedule the charges result under, I respectfully submit that the Honourable Court should grant bail to me in an appropriate amount and with such conditions attached as the Court may deem fit. Thus done and signed at Palm Reach on the 18th of June. It's been duly signed by the applicant and it's been commissioned as well, Your Worship. And then annexure PNM 1 is page 11, PNM 2 is page 12, and then PNM 3 is page 13 and 14, which is the annexures to the affidavit. That's for business.
Mr. Magoo, do you confirm the contents of the affidavit as read and handed in by your attorney? This affidavit is accepted by this court and marked Exhibit G.
As it pleases the court, Your Worship, that's the applicant's case.
Case for the applicant, Mr. van der Merwe.
Thank you, my lord. Your worship, the investigating officer, Lieutenant Colonel Schneller, prepared an affidavit, which I would request to read in with permission of the court. I believe it's the original copy is already attached to the charge sheet.
Yes.
Thank you. Your worship, the affidavit should also be read with the indictment, which includes the detailed charges against the accused, as well as the allegations contained in the preamble, as well as summary of substantial facts. Thank you. I, the undersigned Lily Rolf Schneller, do hereby make oath and state that 1. I am an adult male employed as Lieutenant Colonel in the South African Police Services with service number 04266855-4, stationed at the Directorate of Priority Crime Investigations and attached to the Serious Corruption Investigation Component Head Office. The following facts to which I depose hereto fall within my personal knowledge and belief and are both true and correct unless otherwise stated. A. History. 3. I have been assigned to the investigation of the commission or suspected commission of offences as dealt with further below in the SABC criminal investigation being conducted under Pretoria Central Case 1058-005 of 2019. 3.1. The offences being investigated at this point in time in the above investigation and which are relevant to this application and which it is submitted are at least reasonably capable of being believed or suspected to have been committed as canvassed in more detail below are as follows. Patterns of racketeering activities, fraud, theft, corruption and money laundering, contraventions of Section 4, alternatively Section 5, alternatively Section 6 of the Prevention of Organised Crime Act 1998. The nature, the nature, type of evidence and information acquired during the investigation so far that is relevant to the above listed offences comprises 4.1. The main allegation in this matter relate to the VBS Mutual Bank investigation, which was reported by Mr. Kuben Naidu, who is a Deputy Governor of the South African Reserve Bank, hereinafter the complainant. The complainant reported a case which was initially investigated with the DPCI Head Office Inquiry 7 of 8 of 2018 and ultimately converted into a case docket as per Pretoria Central Case 1058 of 5 of 2019. in his capacity as the Chief Executive Officer of the Prudential Authority, a juristic person operating within the administration of the South African Reserve Bank, established in terms of Section 32 of the Financial Sector Regulations Act, number 9 of 2017. 4.2, the complainant formed an opinion that VBS Mutual Bank was in financial difficulties and as such would be unable to repay when legally obliged to do so deposits made with VBS. On 11 March 2018, the Minister of Finance, acting within the powers conferred upon him in terms of Section 81 of the Mutual Banks Act, read with Section 69 of the Banks Act of 1990, appointed a curator to VBS. 4.3, on 4 July 2017, the Board of Directors of VBS approved financial statements for the year ending 31 March 2017. The Chairman of the Board of Directors was Mr. Chifiwa Matotsi, whilst the Chief Executive Officer was Mr. Andile Mandlusi Atwell Ramavunga, of which both signed the Director's Responsibility Statement to the annual financial statements. The annual financial statements were prepared by the Chief Financial Officer, Mr. Philippus Nicholas Trutte. The investigation has revealed that at the time of the approval of the annual financial statements by the Board of Directors for VBS, Matotsi, Ramavunga and Trutte were all aware that the statement of financial position contained in the annual financial statements was false and that the complainant concludes that VBS was in truth insolvent at 31 March 2017. Investigations have further revealed that the DI returns that were submitted to the South African Reserve Bank, in brackets which form part of the attachments of the complainant's founding affidavit, closed the captions, were actually not a true reflection of the financial status of the bank. 5. VBS Mutual Bank was a mutual bank as defined in the Mutual Banks Act 1993. Further, that there was a relationship between VBS and a number of companies in which huge amounts of are allegedly to have been paid into from VBS. Whether the relationship in terms of the directorship or any other form, on 13 November 2018, upon the application of the Prudential Authority, VBS was put under compulsory winding up by the High Court of South Africa, Gauteng Division, Pretoria. Mr. Anush Rupal was duly appointed on 14 November as a provisional liquidator for VBS, where the powers are set out in Section 3861 of the Companies Act 1973, read with Section 75 and 76 of the Mutual Banks Act, and the extension order was granted by the High Court on 13 November 2018. 6. Huge investments were made with VBS by 20 different municipalities from 4 provinces. The investment by the municipalities of state funds into VBS and not a recognized institution caused them to contravene Section 173 of the Municipal Finance Management Act of 2003. Investigation has revealed that the said funds paid brokerage commissions to entities and to individuals to attract more deposits, mainly from municipalities. Trutte in his capacity as Chief Financial Officer of VBS controlled and operated the banking system of VBS. Furthermore, Trutte prepared and of course to be prepared the annual financial statements that were signed by Matotsi and Ramavunga. 8. Mr. Poppy Mukobwane, in his capacity as the Head of Treasury and Capital Management of VBS, controlled and operated the banking system of VBS. Mukobwane controlled the financial records of VBS and prepared the returns in Section 53.1 and 53.3 of the Mutual Banks Act and as read with the regulations. On 7 9, on 17 July 2017, Mr. Sipho Malaba signed the Independence Auditor's Report for the audit of the financial statements, in which he gave an irregular audit opinion in respect of the annual financial statements for the year ending 31 March 2017. 10. On 1 October 2013, Mr. Falapala Avishoni Ramakosi was appointed to the VBS Board of Directors as a non-executive, and he remained in that position as at 11 March 2018. At all material times from 1 April 2016 to 18 March 2018, Mr. Ramakosi was the chairperson of the Audit Committee of VBS. On 4 July 2017, Ramakosi, in his capacity as the chairperson of the Audit Committee, signed the Audit Committee report as part of the annual report of VBS for the year ending 31 March 2017. 11. Mr. Ernest Nesani and Mr. Paul Magula, by virtue of their positions as directors of VBS, were entrusted with the oversight of the internal financial control system within VBS, and thus with the oversight of the receipt and custody of monies on behalf of VBS. Amongst the monies that were invested with VBS was an amount of 350 million invested by the Public Investment Corporation, PIC, in brackets, of which both Nesani and Magula were representatives of the PIC within VBS. In that both Nesani and Magula, unlawfully, falsely, and with the intention to defraud to the prejudice of the PIC in circumstances where there was a fiduciary duty on them to act in the best interest of the PIC, failed to disclose to the PIC and or employees of the PIC that VBS offered existing VBS shareholders such as the PIC participation in the so-called second rights issue, where existing shareholders would be entitled to take up 2 shares for every 1 share held in VBS, and or of the existing VBS shareholders, only Valley Investments participated in the second rights issue, resulting in a dilution of the PIC's shareholding from 25.26% to 12% due to the non-participation of the PIC in the said rights issue, as Valley Investments became a 53% shareholder in VBS. B. The personal profile. 12. The first applicant is currently known as Chifiwa Calvin Matotsi. His identity number is 77071854068082, age 42, residential address 30 Green Street, Bryanston, Gauteng, work address unemployed, assets. Applicant has the following moving assets: DG 66 JWGP, a Range Rover 5-litre Vogue, MASIND 2GP, it's a BMW X5 automatic, CY82DG GP, a white Suzuki, VDR 041 GP, a white Opel Corsa, WCT 308 GP, a black Land Rover, WVB 843 GP, a Swift trailer, BH13SH GP, a silver Volkswagen, and FM25NZ GP, a silver 3 Series BMW. His marital status is that he is married, is a citizen of the Republic of South Africa, and he has no previous convictions. 13. The second applicant is currently known as Andile Malusi Atwell Ramavunga, ID number 791055362084, age 40, residential address 401 Tilford Road, Cedars Creek, Neatwood, 4 Ways, Gauteng, work address self-employed at the same residential address. His assets CX51DB GB a white Audi, FH07ST GP a black Land Rover, and NJJ227 GP a green Alfa Romeo. He is married and is also a citizen of the Republic of South Africa. Also no previous convictions. 14 is the fourth applicant, is currently known as Poppy Londolani Mukodobwane, ID number 8411255281-082, age 35, residential address Unit 129 Bantry Road, Bryanston, Gauteng. His work address is he is unemployed. His assets are the following: movable assets, CN04HNGP, a white Audi, FR02YCGP, a white Mercedes-Benz. His marital status is not married. Nationality is a RSA citizen. Previous convictions also none of the on the known details of the applicant. The fifth applicant is currently known as Nklankla Calvin Sipu Mlaba. His ID number is 730505-6246-088. His age is 47. His residential address is 708 Paddock Close, Cedar Lakes, Four Ways, Gauteng. Work address, self-employed at his residential address. His assets are the following: PRR523 GP, a white Toyota Land Cruiser, DC55RBG white Land Rover, THK071 GP, a black Ford, FF95SF GP, a grey Mercedes-Benz. The applicant is married. He's a South African citizen. Apologies. And he has no previous convictions. The sixth applicant is currently known as Falafala Avashoni Ramakosi. Identity number 7308035257-088. Age 46. Residential address is 11A Henry Road, Edenburg, Sandton, Gauteng. His work address is unemployed. The movable assets known to him is BLM 219 GP, a blue Volkswagen Golf, DG26NV GP, a blue Jeep Cherokee, 003 PR GP, a red Volkswagen Golf. The applicant is divorced. His nationality is a RSA citizen, and he also has no known previous convictions. 17, the seventh applicant is currently known as Tifalem Bilu Ernest Nesani. Identity number is 7811035453-086, age 41. His residential address is 15 Kaku Crescent, Willow Acres, Extension 9, Pretoria, Gauteng. His work address is he is self-employed at the above residential address. The movable assets to his name is ZCL848 GP, a silver Volkswagen, FS81DT GP, a grey Ford Ranger, DX11ZD GP, a silver Toyota, NPS 688 GP, a white Toyota Conquest, XSJ768 GP, a white Toyota Quantum, and YXJ267 GP, a white Toyota Quantum. He is not married. His nationality is a RSA citizen, and he also has no known previous convictions. 18, the eighth applicant is currently known as Paulus Ndicheni Magula. Identity number is 7603145463-083. His age is 44. Residential address is 11 Tain Avenue, Robindale, Randburg, Gauteng. He is unemployed. The known assets are HG50FCGP, a white Mercedes-Benz, and CJ89NWGP, a grey Ford. His marital status is that he's married. He's a RSA citizen and he also has no known previous convictions. C. Reasons for not opposing bail. 19. The current matter against the applicants involve a Schedule 5 offence. The applicants will stand trial on serious and prevalent charges. The state has a strong prima facie case against the applicants. 20. The state has confirmed all the addresses of the applicants. 21. The state has set out strict bail conditions for the applicants and the state is of the view that the control measures will suffice to monitor the applicants. 22. The state thus has no objection to granting the applicants bail in this matter and request the Honourable Court to take into consideration the bail conditions that will be tabled to this Honourable Court. 23. The commission of the statement by Lieutenant Colonel Schneller. He is present in court to confirm the contents if required or answer any questions of the court. Thank you, Worship. I would then, will it be Exhibit H? I would request this Honourable Court to mark it as Exhibit H. Thank you. That's a case for the state, Your Worship.
Shall we check if we can do that and check here the
All right.
Waar ken jy baie presies? Gebeur iets elke dag. So wat is die vorm 7 wat jy sê?
Nee, die J7 is as hy tronk toe gaan. So hierdie
J7 is sy lasbrief wat hom tot 'n hegtenishouding.
Okay, maar
Nee. Kyk die landros gaan die J7 teken.
okay, maar as hy hierdie het sy fine, as hy J7 beteken.
Dit lyk die
Nou,
enigste
dit is
probleem
nie,
wat ek kan hê is hy is nie
geteken
geteken is.
Ja.
Kan net maar dit is prakties nie moontlik.
Hoe het hulle hom vir jou
Kan hulle
deurgestuur?
nie
My geëpos.
Okay, maar kan hy hom nie teken en hom dan vir jou e-pos
teken
nie?
scan?
Die mense hier so op iets normaal.
Nee,
Ek gaan maar hoor wat sê.
ja.
Okay, ek sien nie wat
as well as representatives of the non-unionized employees